What I do is instruct a lawyer who files a case in court, the rules of pleadings, my statement of claim. If she has a defense to it, she files a defense. We go through the full log of trial. A judge to whom we have submitted our dispute decides the matter one way or the other. It could be from the magistrate court, it could be at the high court. On the average, that takes like 2-3 years conservatively for you to resolve your dispute at the high court. If I'm satisfied, it ends the matter there. If I'm not satisfied, I have a constitutional right to approach the Court of Appeal. And on the average, that will take another 3 years, on the very average. And that's been very conservative.
We've calculated 6 years now.
Yes, 6 years done already. If I'm still not satisfied with the verdict of the Court of Appeal, I have a right to approach the Supreme Court. And on the average, that will take 5 years. So by the time you sum up, by the time you sum up all of this, it takes an average of 11 years to resolve dispute between litigants going the conventional dispute resolution mechanism. And so what ADR has come to do is to provide other means by which dispute can be resolved between parties without necessarily going to court. And that's why we have what's called, it's an alternative dispute resolution. And
what are these other means?
okay, quite a number of them. I'm sure we'll talk about them in the course of this program. The commonly resorted means is mediation. Okay, mediation is a process by which disputants have a neutral, a third-party neutral, help them facilitate resolution of their disputes. The mediator is unlike the conventional litigation. The mediator is not a judge. What it does is to assist the parties to identify their issues, explore possible solutions, and then guide them through the process. Ultimately, the parties' own decision, the terms upon which they resolve is also determined by the parties. That's mediation. We have arbitration, which is usually in the contracts between parties. There's all called dispute resolution clause in contracts. Parties agree that if there's a dispute, we'll approach an arbitrator who takes evidence. It's similar to litigation, except that it is flexible and
it doesn't take so much time.
It doesn't take so much time. It doesn't take so much time. On a good day, a dispute by arbitration could resolve in less than 6 months, compared to the 11 years we spoke about.
Actually,
Yeah.
am I right?
Yes.
Okay. Actually, what type of cases, does ADR, attend to?
Thanks once again. A very broad range of cases. And particularly,
elections just finished in Edo.
Yes,
does it take election cases?
It does, and yeah, it does, and quite a broad range. And Mr. Adeleye has said, as long as the parties agree, then both parties can go to a certain dispute resolution process. So, for instance, at the Lagos Multi-Door Courthouse, we handle cases that are oil and gas cases, telecommunications, simple landlord and tenant cases, and even these election disputes you're talking about. Oh, definitely. marital disputes, building and construction disputes. It's such a broad range of cases that ADR can take care of. There's practically or almost nothing ADR can handle, apart from circumstances where if you have a plot of land, for instance, and somebody is encroaching on your plot of land, it's not time to run to ADR. That's time to run to the court. So it's not a one-size-fits-all. That kind of circumstance, first of all, you should go to court and probably get an injunction. So we're not saying it's for everything, but you can pretty much use ADR for any kind of dispute right now. And in addition, in Lagos State, typically ADR is used for civil disputes. But right now, ADR is crossing the boundaries into restorative justice, where you can have small or minor criminal offenses that are handled through restorative justice, which is a process in which the system is trying to, as much as possible, restore the victim back to the position they were before. So if you have maybe a public affray disturbance in the public and somebody hits another person, you say that's an assault, for instance. So restorative justice can deal with those kind of cases, particularly in Lagos State. Of course, you know, Lagos State is always at the forefront of this type of things. So you can see ADR is a broad range, moving from civil cases all the way even to minor criminal cases right now in Lagos State.
Okay, we are Africans and we have the African mentality, we have our culture, which is a great influence on our society. So I want to know, does our culture influence ADR processes?
Yeah, definitely.
Okay. Certainly. As a matter of fact, the whole concept of ADR flows from our culture. In our culture, you find that disputants would typically approach the head of the family to help them resolve disputes that may have arisen between them. So there is the understanding and appreciation of a third party helping parties to resolve their disputes. So ADR itself flows from our culture, which encourages cooperative approach to solving disputes, because there is a recognition of the fact that the interest of the parties transcends their positions or their rights. You understand what I'm saying? So if we do understand that we are members of the same family, we rather want to collaboratively or cooperatively resolve our dispute in such a way that our relationship is still sustained and maintained. So it's an outflow of our culture.
Adding to that, the issue of going to court, especially in solving marital dispute, I've often heard that when you go to court, you know, to solve your marriage, you cannot come back and be friends.
So please hold your thoughts. We need to go on a short break. There is a
technical issue.
We'll be right back after the short break. Please stay with us.
Thank you.
Let the conversation continue.
When I went to Computer Village to grab an accessory for my phone, I already got the accessory. I didn't check because I was still a JJC that time, and then when I got home, I figured out that the accessory I got was second hand, first of all, but I paid for new price. And when I turned the phone on, the battery just swelled up. The same day I got it, I wanted to go back, and the shop where I thought I bought the thing, they said the guy I bought the thing from was not working for them. I was just wondering, like, how would they deny something that I just got the same day? And then it just opened my eye that anything can happen in the streets of Lagos.
Thank you for staying with us. We were still discussing the role of alternative dispute resolution in modern legal systems, and I asked how culture influences the activities or the processes of alternative dispute resolution. Adebimpe, you were talking about marriage.
Yes, I was talking about marital dispute, and you know, I've heard over time that when you go to court, you know, to resolve marital conflicts, you cannot come back and be friends.
Yeah.
So I think that also corroborates with what she said about culture, you know, having an impact in alternative dispute resolution. I want to also find out, you know, you've treated many cases. I'd like you to share, you know, one of the success stories in handling such cases.
Particularly for marital
For
disputes?
marital.
I think that's a great question, because not only do we resolve marital disputes, that's not the divorce. Hope you know the court, if it's parties.
Divorce, yes.
But the ancillary issues,
Okay.
then you can bring it to the Lagos multi-door courthouse.
Okay.
Ancillary issues such as property,
Okay.
or access, custody of the children. Those are the type of things that we handle.
But in Nigeria, who really has custody of the children?
Oh, it's dependent on the parties.
Okay.
So the court can take a decision if it's before the court. But if it comes to somewhere like mediation or the multi-door courthouse, for instance, then the parties take a decision. Do you want joint custody? Or do you want access and custody for one person? Those decisions are taken by the parties. Remember, mediation is a process where the parties are in ultimate control of the decision to settle. And that's the beauty about it, because when you make the decision for yourself, then you want to abide, you know, by that decision. And then back to what you were asking, a success story, we find out that in these cases, they lend themselves very easily to mediation, because speaking from the cultural perspective, ordinarily, where would you go to resolve your disputes if you have a marital dispute? This is family. So you can see the mediator as that third person who is skilled. So it's not just a family person.
And who is neutral?
Who is beautiful, looks like you. I was going there. And who is neutral, and that's the difference. You have somebody who is neutral, who is then skilled, and who can keep the confidence, which you wouldn't find in the family. And this is all done within a beautiful environment. And when that is done, the parties can go home and abide by the terms.
Okay.
A beautiful case, and many cases have happened, is where we had a husband and wife who were in the room, and the mediator left them in the room. At some point, you can actually leave them to have a conversation. And she peeped to find out what was going on. They started gisting.
Oh.
At the end of the
My
day...
mind had gone somewhere else.
At the end of the day,
Okay.
what happened was that they didn't just resolve the dispute. There was no more divorce on the court end. Yes. So we signed terms of settlement, and there was no more separation. So we have so many success stories like that, where parties actually get a resolution that is enduring for marital disputes.
Oh, fantastic.
Yeah.
Okay, so I said I was going to ask for lawyers, how has the perception of alternative dispute resolution evolved among legal practitioners and the public over the last few years?
Okay, at the onset of alternative dispute resolution, lawyers were initially not very receptive. to,
And why?
well, they felt that it's, you know, you want to earn your fees. And when you have the matters resolved, they feel that it's a way of shutting them out of earning their fees. But over time, I think the awareness has become better.
Yeah.
The court system itself has, you know, revised its rules to encourage parties to amicably resolve their dispute. Lawyers no longer see it as an impediment to their fees. And so we're having a large army of lawyers supportive of the process. I'm a lawyer. I would rather have my matter resolved within 6 months and my fees and move on to the
Definitely.
next case
Yes.
than have to wait for 11 years.
Yes.
Time value of money. Even what you have agreed to earn at the beginning will have no value at the time the case is resolved. So we're having a better receptiveness to alternative dispute resolution, even by the legal community. And like I said, the judicial system itself has embraced alternative dispute resolution. Virtually all the rules of all the courts have provisions encouraging parties. And as a lawyer, you have no choice in the matter. It's obligatory. You must go through this process. And I'll give you an example. There's what we call collaborative law. Collaborative law provides that the parties as well as lawyers appointed by them will sign to an agreement to resolve dispute without going to court, right? A part of that agreement is that if they are unable to achieve resolution and they have to go to court, the party must retain another lawyer. So what that does is to encourage the lawyer retained from the onset to follow through the process. To follow through the process. So it's the new thing, really, and the party lawyers are really bracing up to it.
So I'll come back to ask you how residents are now accepting that. But my colleague Abibola has a question for you.
Because I'd just like to ask, since we're talking about ADR and modern legal systems, how would you, and you're talking about success stories here, fantastic
Success story, yeah.
There are challenges. And of course, in a society such as ours, where everybody thinks, oh, I don't want to go to court, I want it hush-hush, I want things to be resolved. So can you also take us through some of the known challenges or some of the immediate challenges that ADR is facing here in the US?
Well,
You
I will start with benefits. I don't think we've heard the benefits before we delve into the challenges, right? Okay. So particularly in Lagos State, a crucial benefit is the fact that you can get your matter referred from the court itself, which wasn't there before. So you walk to the court, and the court rules provide that the Lagos Multi-Door Courthouse will screen it into ADR if it is suited for ADR, and that's a huge benefit, and many other states have taken up this also. Now, when you speak about challenges, what are the challenges? Like I said, it's not a one-size-fits-all.
I think that's where my own question will come in. That how receptive are Nigerians or Lagos residents to this new legal system?
Very receptive. So a major challenge I mentioned earlier, one is it's not for all cases. So we've talked about the benefits, we've talked about land cases where you need to get an injunction. Even for marital disputes, if you have domestic violence, definitely you're not going to bring it to ADR, to alternative dispute resolution. So it's not for every single case, and that's a challenge with alternative dispute resolution. Another thing is the submission of parties, and then you're talking about communities too. How do people... So you could file a case at the Lagos Multi-Door Courthouse, and the other party says, I don't want to show up. How are you going to compel me? Isn't it? So that's a challenge. So but the beauty about it is that in the practice direction, you're required to appear before an alternative dispute resolution judge. So you see the system has created answers to, I think, pretty much a lot of... So for that challenge, an alternative dispute resolution judge will summon the recalcitrant party to appear before the judge to give reasons. If you want your dispute resolved, and that's why we're having the courts overburdened. If you want your dispute resolved, why don't you want to sit around the table and have a conversation with an expert leading you and guiding you? So that challenge has been taken off, by an alternative dispute resolution judge.
So do you work hand in hand with...
I have one.
I was going to identify two other challenges.
Affordability?
Well... No, it's actually cost effective.
Oh, okay.
Quite cost effective.
Oh, okay.
And,
quite.
Now, I was going to talk about two other challenges that one can identify. Initially, we used to have this challenge of enforceability of agreements.
I was about to ask that, how do you ensure that?
Yes. But the rules of the High Court in Lagos, for example, has addressed that. Such that where matters are referred by the court to the LMDC for mediation and settlement is reached by parties, it gets signed off by the ADR judge and becomes enforceable as a judgment.
As a consent judgment.
Consent judgment.
Yes, if it's a walk-in.
The High Court. So that has also been addressed, the issue of enforceability. It has its own limitation, really, in terms of discovery of information. For example, you will find that dispute between two parties, one of them may have advantage of information as against the other. Under the structured process that we find in the court, you can apply for discovery. You can compare the other party to disclose information that you need to build your case. But in mediation, that is not readily available. So there could be a bit of imbalance at the end of the day.
table.
At the end of the day. Then, of course, for example, in labor and employment matters, typically there is inequality of bargaining power at the onset. The employer would always have an edge over the employee. That may also play out where there's a dispute between them. So there could be a bit of imbalance. Those are the, if you like, the downside of but ultimately, at the end of the day,
it works it out.
They work it out.
Yeah, alternative dispute resolution still even works out those imbalances.
But have you experienced cases where the court directs them to come to ADR, and then after all said and done, the issue is not resolved? Do you refer back to court?
Oh yes, oh yes. It goes right back. So two ways. The court could refer. You could walk in. So you could, anybody, you have a dispute now, just walk right into the Lagos Multi-Door Courthouse, or the court refers, which is the circumstance you're talking about. And if it doesn't resolve, and our timelines are maybe about 90 days, 180 days, 1 day, 2 days, very short timelines. If it doesn't get resolved, then it goes back to the court system, which is the beauty about it. We then do a report to the court saying this is what happened, and then the court takes it up from there. And then the beauty about it is that the parties know we have made an effort. We've tried to resolve this. We've got an expert. It didn't work. So the court will then move into trial and take it up all the way until they get a decision or a judgment of the court. And then at any time, you find out that some cases have done a full circle. We've sent it back to the court. And then they wake up later and they appear in the court and say, hey, I still want to resolve this. We're at a point in our negotiations. Can I come back? They come right back to us. So it's actually a system that is working in favor of the parties that use the processes.
Okay.
Yeah, I wouldn't say that, that a matter has gone through trial, maybe a failure of mediation, for example, goes back to trial, does not close the door for parties to still find a way to resolve their dispute. Even judgments can be discussed. And parties agree on compromise. And once it is signed off by both parties, it gets implemented. And so there is no end to parties engaging, discussing, finding a way.
There's always room for
There's always room.
There is.
Even at the Supreme Court. Even at the Supreme Court, there's always a room.
And the Supreme Court and Court of Appeal now even have mediation programs. So you can imagine, at the Court of Appeal, at the mediation court, at the Supreme Court, at the High Court, at every level, that opportunity has been created for parties.
Okay, you've been talking about multi-door. I'm sure many of our viewers are wondering, what is Lagos multi-door all about? So can you shed more light on the role of multi-door and how it has evolved since it was established here in Lagos?
Okay, so the Lagos Multi-Door Courthouse is the first court-connected, so it's connected to a court. Yes, alternative dispute resolution center that provides alternative dispute resolution processes for parties. So the ADR processes, alternative dispute resolution processes, mediation, arbitration, dispute, early neutral evaluation, and so on and so forth, a broad range of things that parties can use to resolve their disputes. It started in 2002, so we're over, that's about 22 years old now. And it doesn't only resolve cases, it also does a lot of training and goes into restorative justice, right?
When you talk about training,
we found out when we started out, we found out that we had a dearth of information, of knowledge. So we started training about 5 years after inception, or thereabout. Started training people to be mediators. So we needed to standardize the training process. So we currently run a training program for mediators to become specialists in mediation. So we do case resolution, we do training, we do restorative justice, and so on and so forth. Now, in the last over 20 years, we have resolved over 7,000 cases. Not just the number of cases, we have taken in over 25,000 cases in the last 22 plus years. And then for commercial disputes, it will amaze you to know that if the Lagos Multi-Door Courthouse didn't exist, claims to the tune of over 50 billion would still have been within the parties. Yes, we have resolved disputes to the tune of over 50 billion, which means this has been released to the economy for use. And, and not only that, and that's in Naira, I'm not calculating in dollars, over $50 million has been released into the economy by virtue of resolution of this type of cases. So essentially, that's what the Lagos Multi-Door is about. And it has different things it does. Either you get your cases from the court, disputants can walk in from anywhere, or we could do direct intervention also. So some parties don't want to approach us, but we see there's a dispute going on. Somebody gives us a call and says, hey, there's a dispute going on there. Please go and intervene, because, you know, there's ego. Nobody wants to submit. Then we go. So those are the three ways you can bring in cases to us. Either you walk in, or we do a direct intervention, or the court refers, you know, the cases to us. So it's the Lagos Multi-Door Court is the first in Africa. So it's from us, Abuja, and the remaining states, then copied, not just our laws, and I'm sure my people are hearing me, but just what it is.
If you permit me to add, Lagos Multi-Door Courthouse is actually a very bold step by the Lagos State government to integrate alternative dispute resolution into the court system. The Chief Judge of Lagos State, my Lord Honorable Justice Kazim Olarewaju Alugba, set up the Governing Council to assist the multi-door courthouse to achieve the fundamental objective for which it was set up, which is basically to decongest the court. The current Governing Council is under the leadership of my Lord Honorable Justice Jumoke Olushola Pedro, who is ably leading the multi-door courthouse to achieve the fundamental objective, which is to decongest the court. Decongest the court.
I still have a question about training. What kind of training qualification does one need, you know, to become an arbitrator? Okay, so an arbitrator is different from a mediator. The mediator, yes. Right? So for arbitration, we have different institutes that provide that training. Chartered Institute of Arbitrators, you either become an associate, a member, a fellow, and that's what's required. You go through certain teaching programs, and then you write your exams, and you get a certification. So it's a simple process, but it's a tough process. You could try it.
Still wanting to know more about the Lagos Multi-Door Courthouse. We have the Office of Public Defender and Citizens Mediation Center. So what is the difference?
Yeah, take that.
Okay, so for the Citizens Mediation Center, great question, because they also provide mediation services. Particularly, they are the grassroots, and they provide mediation more for indigent parties, and that's what their law provides for, more for indigent. But you find out that for the Lagos Multi-Door, you heard me talk about the broad range of high-ticket cases that come in, and the second thing is that we're court-connected. So the Citizens Mediation Center is linked to the Ministry of Justice, while the Lagos Multi-Door Courthouse is a court-connected ADR center to decongest the courts of cases. So even the Citizens Mediation Center, for instance, if you sign an agreement at the Citizens Mediation Center or a Memorandum of Understanding, that Memorandum of Understanding still comes to Lagos Multi-Door Courthouse because it's connected to the court, so that terms of settlement or Memorandum of Understanding can become a judgment of the court. So that's really is the difference. Then the Office of the Public Defender, really, they do mediation in between, but essentially is the Office of the Public Defender. They're there to defend the public. So if you have a case and you don't have counsel, then you can approach the Office of the Public Defender to represent you in the court system. So those are the nuances and differences between all three. Okay,
so how would you see the future of alternative dispute resolution in Nigeria?
Okay, great future. Especially now that we have the possibility of leveraging on technology. One of the advantages of alternative dispute is flexibility, right? You can have your dispute resolved without necessarily going to a location. For example, you need to go you need to resolve your matter in court, you have to go to Ikeja, but you can resolve it in the comfort of your home, even using online mediation, online settlements, online dispute resolution platforms. So we have mediators who are trained to intervene online, real time, without leaving the comfort of their home. And disputants as well can also explore the same platform, the same mechanism to resolve their dispute. So the future is quite great, and because of the many benefits, it's catching up fast. Not just with disputants, but also with legal practitioners.
Do I need to study law to be a mediator?
Oh, no.
You don't have to.
So on our panel, and that's good, on our panel we have we have over 300 neutrals. We call them neutrals. They're both mediators and arbitrators on our panel.
Okay.
And these 300 plus people are engineers, doctors, lawyers, accountants, bankers.
Yeah.
They work full time.
Okay.
But when we have a specialized case, they come in and handle it. And that's the beauty about what we do. So you get good
I
hands.
can be a mediator.
Yes, you can.
Thank you for
Would
coming.
advise you the next training session.
When is that?
Okay.
I
When
think
is that?
When would that
it's
be?
in November.
Okay.
It's in November.
Okay, Joy, get ready.
Watch out.
Thank you for coming. As we've learned today, alternative dispute resolution is playing an increasingly important role in the legal system here in Nigeria. We've been talking about the role of ADR in modern legal systems with Olufayo Adeleye. He's a member governing council, Lagos Multi-Door Courthouse, and Acheri Cole, director, the Lagos Multi-Door Courthouse.
Thank you.
ADR again is alternative dispute resolution. Before my producer cuts off my name. We'll go on a short break now. When we come back, the conversation continues.